was oppressive. I believe in several of the points that are made on the petition. So why is it that you, who represent us, get the decision of what we feel oppressed by?
Well, once again, I think it comes down to reading those two statutes.
But again,
in context.
oppression is one of them, Bill. And how do you know what I feel oppressed by? I felt oppressed. So there's 6 people up here that represent a town of 2,700 people. Over 15% of your voters signed this petition, and you're still arguing about whether the town was oppressed.
Well, what you feel is not what constitutes a basis for a valid claim on a petition. What you feel, I'll give you that, but it's got to be specific and factually accurate on the petition, and it's got to rise to the level of the ground statement.
Okay. So my feeling and my opinion and knowledge of the situation is less than your knowledge, because based on my knowledge, it does reach those things.
Okay.
Reading all the same statutes, don't think that the homework wasn't done by the people that circulated the petition, and if there were questions, it was explained very clearly.
Well,
I
maybe,
felt fully confident signing the petition that the grounds were there.
maybe you can help me then with these claims. Maybe you can help show me how these various claims are specific enough, are factually accurate enough, and rise to the level of the ground statement.
As Mark said, there's a link to a video on one.
But it's, okay, which isn't there anymore, but I mean, it was perhaps at the time that the petition was being circulated. But beyond that, is there anything else that?
I don't have a copy of the petition, I guess. What are the specific?
Well, like for example, let's just like the mayor proposed and initiated the elimination of EDD without consulting any of the community bodies EDD directs or works with, illustrating his personal agenda when he took office.
I think it's been very publicly documented that neither the chamber or the HABC were consulted by the mayor before, or the council before that position was made.
Well, is there a requirement that he had to?
I guess not, but
It's a city paid position. Did he have to in fact do that? And are you suggesting that he couldn't have an opinion that
if
position
the
wasn't?
special meeting, then after eliminating the position and going through the whole recall, when you guys were laying out the duties for that, the mayor made it very clear that volunteers should pick up those duties. Did the EDD previously? Is that our absolute responsibility? We didn't get any say. So is it that just because you're mayor, you get to say who does what? Because granted, yeah, that was a city position that was eliminated, who oversees and works with several city boards. But now he's requiring that, or suggesting that all the volunteers do the work.
It's his opinion. He's not entitled to have an opinion that's contrary to yours.
I'm not saying that. But I'm saying as the people you represent, how can you decide what our opinions are with the petition? And that's all I want to say. I just want to say there's 15% of this town that signed and submitted a petition under the grounds that they believe the mayor needs to be recalled, whatever their specific reasonings are. Everyone agreed with something on that petition enough to sign it. What were there, 80-some people that showed up at the last city election? You had over 300 sign the petition. 280-some which were valid, and I would guess more than that were just because some of the got thrown out because of notary. That's a pretty significant increase of people who in 6 months have taken, or 8 months, a very spiked level of interest in city government.
Okay, thank you.
And Travis, just to build off that, I understand Mayor Campbell has not won the popularity contest in this town at all. I think some of his actions he regrets. And I don't necessarily.
Why is he here? Why is he here?
Never expressed that.
Maybe not publicly, he may not, but in conversations with me, I would say that there's decisions that he's made that maybe he didn't quite handle the situation as well as he should have. I think we would all agree to that.
And
My-
speaking to that, I'm an assistant.
Hold on,
in
let me
licensure.
finish, please.
My job tonight, as I'm being advised, is to take a look at the petition that's being provided and how does this stand up against the statutes of South Dakota. I get all of us in this room have an opinion, and I respect everyone's opinion here. I know how you feel specifically because you shared that with us, and I value that, I really do. Unfortunately, that's not part of the scope of the decision that I have to make. I know why you signed the petition and so forth, but what's in scope for me based upon this decision is, does the petition meet the criteria that's been laid out in front of me by our city attorney?
And I still don't think it's clear enough as to why you guys get. No one is, and again, we're gonna go all night if it's allowed back and forth on whether you have the opportunity to make a decision or not. But to me, that's, you represent the town and you also need to remember that.
I
And
agree.
that's my opinion. And as far as being, publicly expressing things, I'm in my second year as one of the assistant chiefs on the fire department. I've done some things that have made people mad. I've not gotten along with people. I've made bad decisions. Part of being is coming back and saying, I messed up, I'm sorry. And that has not been done. It's gotten more tense and it's become more and more of a power struggle between both sides.
I agree, it has not been a healthy situation for Hartford. In fact, this is a pretty sad event that this is what had to come to.
Very, very
But
bad for Hartford.
But then the question at hand is, are those grounds for the petition for a recall? And you guys are saying yes, and I understand that, but I have to go based upon the city attorney's recommendation or explanation and try to come up with that decision.
Guys, I'd like to start wrapping up. I will allow you two to also start at that podium, but I would like to ask that we can move forward quickly on this issue. So if we can, just limit to just these two, please. Obviously, if you two have something that you want to say, and the council does override me, that is, their discretion. But I would like to try to wrap this up, just so that we can expedite. We got a lot more business to cover, and I, hope that you guys can understand. Okay, James?
All right, James Bus, 720 East Highway 38. Okay, so I'll keep it short. I'm not going to try to argue case law. This is ridiculous. Did you not say that they have to basically see that one of these things is true, correct? When you were describing what they're looking for, you stated that only one of the items needs to be true to go on to prove oppression or gross partiality. Is that not correct?
What I said is that when they look at the petition, the first question they have to decide, is it specific or is it general? Does it satisfy the statutory requirement that it specifically states the grounds? The second thing I said, if you had come to that and said, yes it is, then you have to decide whether or not what is alleged is factually correct. Because if it didn't happen, you have no business signing a recall petition based upon something that didn't occur. I.e., the mayor showed up in a swimming trunks when everybody said that didn't happen. The third thing I said is that once you get past that, you have to sit down and say, does it fit the definition of oppression, or does it fit the definition of gross partiality? And once you get through those first two steps, then you're at that third step, does it fit the definition?
Okay.
The question that was asked to me, do they have to substantiate all of them? And the answer was no. Implied in that answer is one sufficient, and the answer was yes.
Okay, so if we can substantiate one under those three guidelines, okay, Bill. The mayor has consistently refused to allow citizens to address the council. We've already put the case together that yes, he did, at least once, several more when they stood up, but at least once, correct?
Well, then there's a difference between once and consistently.
You guys want to stand up again? Show who didn't get to talk. Okay, this would be consistent. Would that not be true?
Well, again, I can't recall these people not having an opportunity.
We spent enough time arguing.
Now, we can go around and around on that, but it's not, there's
Is it not consistent, guys?
there, but go
Realistic.
ahead.
Okay, what was your second stage of this? Factual, okay. So was it not a fact that Tony Randall could not stand up and talk? Yes. I think that was a fact. Was it a fact that he asked other people to sit down? Was it a fact that he asked us to all get kicked out of here if we made any noise? Yes. Okay, so we said a fact. What was our third step?
Your third one, does it fit the definition of
Does it fit the definition of oppression?
oppression?
Okay. Oppression. That to me sounds like if you're telling somebody what to do and not giving them the opportunity to speak at a public forum or a public meeting, that's being oppressed. Whether it's to your level of oppression or his level of oppression or their level of oppression, that doesn't matter. It's oppression. It's telling somebody they can't do something. They cannot come up and talk at a public meeting. That to me is oppression. So I think number 4, not only has the case been made, but I think you made it for us, Bill. So I think that we've proven 4. I think we've proven oppression. I think we proved the 3 stages. So I think I'm pretty much done. And you guys can make whatever case you want and try to keep defending this, which I don't understand. Why you can watch this for months. You can have 67% of the voters vote one way, and you destroy that guy in the next meeting. I don't understand this. You need to tell me, how can you defend this?
67% of the voters in what?
The EDD election?
Yeah, it was about 60-40 with about.
Well, it's 64.
64%.
64, sorry, it's a little off by like 2%. All right, I'm done, but I think, in my case, looking at this, it's been proven, and it's actually been proven by you guys sitting behind the table.
Well, I must have missed something, I'm sorry. I don't see the one-time concept.
I have a legitimate question for you. For that number 4, Councilor Nelson has stated that it had to be specific versus general. So the mayor has consistently refused to allow citizens to address the council at open meetings. Is that a general statement, or is that specific?
Okay, well, if we're gonna go down that road and you want to be more specific, number 2 would be even more specific to this very same case, actually. The same person, the same situation, the same video on the news for the world to see. How much more specific do you want us to get?
James pretty much said it all, and that's where I'm going to follow up is, regardless of how specific or whatever we say or do on a petition, what I'm hearing tonight from most of you is that it is still ultimately up to your opinion and your opinion only, and not the voters and the people that signed it. If I put on there that the petition says he wore the swimming suit, blah, 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 like the attorney said, you guys could still say no recall.
We've been advised by the city attorney that we are the gatekeeper in this case.
Right. So no matter how specific or what we do, if we do everything you're saying, if you have the votes, you can deny the recall versus what the voters are asking for. So if we meet all their criteria, like you said, that they could still deny the recall. Is that correct? Because it's your opinion. That's everything I hear tonight.
Oppresses me.
If the petition said
Really
that
oppressive.
the mayor should be recalled because he wore a swimming suit to city council meeting, if that's what it said, your first question would be, number 1, did that occur? Okay? And if it didn't occur, you shouldn't be voting for the petition. Number two, you go to the test with, is it factually supported? All right? That in fact occurred. All right? If it occurred, then you go to the third thing. Under the statute, it has to fall within the definition of oppression, or it has to fall within the definition of gross partiality or misconduct, any of those things. Okay?
Now,
And I'm suggesting to you that if the petition said he wore the swimming suit and it didn't occur, it doesn't fall within any of those definitions, and you would have no business proceeding forward and scheduling.
I'm a little confused because you're.
Why don't you answer my question, sir?
I'm a little confused because last time you had, I wrote it down, specific versus general, is what is alleged factual or true, and then does it fit the definition of oppression or gross partiality? The example you just provided with the swimsuit, you started off, is it factual being number one versus specific or general, or number two, is the alleged true? So do we need to take in consideration, because in your last example that you just provided, it was factually true, and doesn't fit the definition. And you didn't state specifically versus general. So I'm trying to understand the criteria. I need to be more.
Okay, the statute says 9-13-13, you shall state the specific ground. Okay? The Attorney General's opinion says you shall state the specific grounds, and that general doesn't cut it. Okay? And so if the allegation were that he came to the meeting, to make it very clear, you want to be saying he came to the meeting on such and such a day, and this is what happened. All right? And the generality, when we look at that opinion that the Attorney General gave, the guy is elected since his election to the post of mayor in May of 1982, when Olaf has exhibited personality contracts inconsistent with the office of the mayor, and that Mr. Olaf has on a continuing basis harassed and intimidated residents of New Underwood, contrary to the best interest of these residents and the community. To which the Attorney General said, in response to the question, do the grounds for the recall enumerated above satisfy the legal requirements for the recall petition? And the Attorney General said it has to be specific. The grounds relied upon in New Underwood are general, not specific. I'm not going to tell you which ones I think are general and which ones I think need to be more specific, but I can tell you what happened in that case. And I can tell you there is a requirement and a suggestion from the Attorney General's opinion and from the statute that you must specifically state what those grounds are. Add on that, when the statute was amended, we now know that the only grounds you can allege are grounds that are consistent with misconduct all the way down to oppression and gross partiality. And I can't do any better than just saying, here's what the law says, and now you have to make the decision.
Thank you for the clarification.
Real quick, Larry.
Sir.
So, what I'm hearing is that we have to make a decision, but that does not mean that we're the ultimate authority on this, correct?
No, let me tell you two things that could potentially happen. If you voted yes, there's something called a writ of prohibition, where someone could come in and attempt to challenge it and say it wasn't factually supported, it didn't comply with the statute, I don't want to have an election. On the other hand, if you voted no, the petition doesn't meet the criteria for whatever grounds that you did it on, and someone could bring a writ of mandamus and could sue you and say, Judge, I want you to order the city council to schedule an election. They didn't have a decision in this matter. They couldn't exercise an opinion on whether or not they felt it satisfied the terms and conditions. It was a pure administrative act on their part. They didn't have a decision. And the judge is going to do something under either one of those scenarios. He's either gonna say, whatever your decision is, you're right, or you're wrong.
Thank you.
Did I answer? Did I-
No, it's a yes or no question.
Answer your question?
Nope, you did not. I'd like a yes or no.
Go.
No matter what, factual or not factual, it's their opinion to have an election or not. They are the judge and jury,
They-
yes or no?
They have to make, I'm not gonna give you a yes or no.
No,
Let's start
it's a yes or no question.
Let's start with that. Not gonna get a yes or no. The answer is, they must comply with the statute,
Right.
the law in this state is.
Yep,
And that's what they must do.
right. And so if it meets all the four criteria that you laid out, okay? It's still their opinion if it meets it. The oppression, it's their opinion. So if I say, if I do a new petition, say, I want to recall the mayor because he would not let Tony Randall speak on October 28th. At this time, he gavelled them down. And that is a form of oppression, okay?
So you're gonna file a new petition?
If I filed a new petition, okay? And it was that specific, like you're asking, they could still deny it, right?
I'm gonna tell you, it relates to hypothetical.
It's not. What I'm saying is, at the end of the day, it is their opinion if it meets all their criteria. It has nothing to do with the petition. Yes or no?
At the end of the day, phrase it again for you, there's a specific statute that says what the petition
Right.
must do.
Right. And if it met all of that,
They.
any petition met that, what would happen?
Need to make a decision. Number one, is it safe for specificity, which is the reason stated. Number two, the common sense, not in the statute, but is it factually supported? Did it happen? That's just the common sense. The third thing is, did whatever happened, does it rise to the level of oppression, gross partiality?
That is always, no, wait. And that is always their decision, no matter what. It's their opinion.
How you do it, it's
They
ultimately
are
their
going to
decision.
have to make a decision on that.
Yes.
So yes, yes,
So no matter what you lay out, if they got the votes, they can do whatever they want.
And their counsel.
There we go. Thank you.
For bad advice. Council President Johnson, I got the name right this time, right?
Yes, you did.
Call you Mayor. I want to bring two things up, and then I'm going to ask for you folks to do something. First thing I'm going to bring up is you have an Attorney General's decision. Attorney General decision is not a litigated decision, correct? Councilor Hogan?
That's true.
It's an opinion.
That's correct.
What we do not know from that opinion is what was spelled out on the petition that was presented to the council. Do we have a copy of their petition?
I can tell you that the Attorney General's opinion tells us what was alleged in the petition. That
Okay.
there was not, just to say, there was not attached to the Attorney General opinion the actual petition.
Thank you. So, pursuant to 9-30-1, which is where we have to have grounds for the petition before we can have you move forward, correct? 9-30. Okay, where it lays out the reason it says that you have to have specific grounds, correct? What I read on this finding from the Attorney General's office is the petition stated the following is the grounds on which removal is sought. Since his election to the post of mayor in May of 1982, Lynn Olaf has personally exhibited characteristics inconsistent with the office of mayor in that Mr. Olaf has a continuing basis harassed and intimidated residents of New Underwood, contrary to the best interest of these residents and the community. Nowhere in that line does it specifically call out one of the grounds that are listed in 9-30, correct?
That's true.
Okay, so why did the Attorney General say that this petition was no good because it wasn't specific? I believe the decision, and because this is an Attorney General's decision, we all get to have an opinion. His opinion in looking to that was none of the grounds stated in law were on the petition, therefore the petition was not specific enough to the grounds called out in the law. I believe that's why the Attorney General took that out. I see nothing on here that says that you have to be specific in the instance. What I see in this
situation here is, they were not specific to the law in what the law called out. The law called out grounds. The grounds are listed in the law. The law says you have to specifically call out grounds for removal, and those grounds are listed up above. Once the grounds are called out, it's specifically called out. Anything below that is now supporting evidence to those grounds, and the Attorney General made this ruling because the grounds themselves were not specified on the petition.
Well, that's your view.
That's
So,
so, Mr. Hogan,
Let me finish.
no,
And I'll let you
here's what I'm gonna say to
What I'm
you.
gonna tell you is what I told you before. And I think our legal counsel has advised this as much, is that you can call a brown dog red. So you've got your ground statement, but if your claims don't support your grounds, then you don't have a valid petition.
Okay.
So you can disagree with me on that.
So I know, I will 100% agree with just what you said. The grounds are specifically called out. The grounds in the petition are called out as oppression and gross partiality. So we have met the letter of the law in that respect, correct? We called out grounds.
Your claims don't support the ground.
Mr. Hogan, stop. Okay, we're not going to claims. We called out grounds, correct? Specifically, grounds have been called out. So the grounds, according to law,
I can
have been
just tell
called
you, any judge is going to assess whether your claims rise to the level of the grounds that you state.
Correct. Now, may I finish, please? Because we're going down the same road here. Okay, trust me. We're going down the exact same road. So let me go down the road without stepping out in front of me. Oppression, gross partiality are called out on the petition. That meets the specifics of the law. So that is there. Now, to the next point of Larry saying that you have to pass the test and you've got a 3-point test. The grounds are laid out. Is that ground laid out in law? Yes, it is. So we passed the first thing is, they said, here's something in law, this is the reason. Now the next thing is, did it really happen? Okay? And I believe that most of you can look at least one instance.
Can you
In
back
fact,
up to that first point? Because
Yes, Brad.
my notes are specific versus general, and
Okay, well, specific versus general, the law says you have to lay out a specific ground. So that's where specific comes from. You could go to the other side of that as this Attorney General's decision. It does not call out anything that was in law in what the petition stated. The petition stated the guy harassed people and he bothered them and he wasn't really behaving like he should be to Mary. Those are generalities and they're not one of the reasons for grounds of removal or grounds for recall in the law. They didn't say that he was oppressing people. He didn't say that he was drunk when he was bothering these people. He didn't say that he was, trespassing on their property and doing a criminal activity. He just kind of laid those things out. So, again, Brad, I guess where I'm going with that is specifically the reasons are there. The reasons that were said in the law that they should be, those reasons are written on the petition. So that's specific general. So now we go to number 2, and is it factual? And I believe every one of you here in the council probably look at the 9 reasons there. In fact, Mr. Haugen, you admitted that maybe one of you should have stepped up and made a motion to allow me to stand up in front of the council meeting that night, but you didn't. So if we're going to imply something, I'm going to imply in that you believe I was oppressed that night, and you probably should have stepped up and let me get up in front of the meeting to speak. But you didn't, and that's fine. But so now we've met number 2, with at least one city member here who said we probably should let you stand up. So we've got number 2 taken care of. And number 3 is you believe that's suppression. Because now we have to say, do you believe that met the definition of oppression? Oppression, did the event occur, and do I believe, as a person sitting there, that meets the definition for the first 2? Takes us right down that list. Now, I will stand in front of all of you tonight and tell you that specific instance, I felt very much oppressed. Because I was not allowed to stand in front of this council as a person who has professional experience in a job you're discussing and share that professional experience with the council. Because I was oppressed and told to sit down. I was not allowed to bring professional experience in my job to show you guys. Do you know how bad that made me feel oppressed that night? Hugely. For the other folks in this audience here tonight who have gotten up at a meeting to walk up to the podium because they may have had some other experience that they wanted to share just like that, and got told to sit down. You're not going to be heard from. Sit down, we don't have time for you. Sit down, we're not going to be here all night. Those are instances that I think any one of you sitting in the council can think back and think at least one time that you remember hearing those words said in this council chambers. So we once again have done number 1, number 2, and number 3. And all it takes is for any one of you to think of those 9, you know what? This one works for me. You don't have to go down and all agree on any one of those 9. Any one of you probably can come up with a situation, but I think all of you can come up with a single one. Now, there's been a huge discussion here tonight. There's been a lot of things brought out on the table. There's a lot of emotions in this room. There's a lot of opinions that have been brought out in this room. There's a lot of legal mumbo jumbo that's been thrown out in this room tonight. There's a lot of things that are confusing to people who have not been around the law. And I think there's some folks sitting at the table that might feel that same way. I truly believe that you need to vote your conscience in what you believe 314 people in this town were thinking when they signed a petition. And I will stand up here and tell you that I believe all 314 of those people, if the city ends up in a lawsuit being sued over your decision tonight because you agreed with them, all 314 of those people will applaud you and thank you for listening to the citizens of Hartford and making the decision to move forward with what they've asked you to do. That being said, I would sure encourage one of you guys to call the question and move this forward.
Well, before no, I'm going to respond to you. I guess I disagree with you in regards to what you just said. Okay. So we heard some definitions on what constitutes oppression earlier tonight. It's a given that we don't have any controlling authority here. It's all persuasive authority, which means it's not on point. We've got some definitions that come from case law related to contract disputes and disputes over how matters are handled in business entities and so forth. But we're trying to get to a definition of oppression. One of the definitions that was stated was from the, and this is from the Baldwin versus National College case from 1995, states that oppressive is defined as unreasonable, burdensome, unjust, severe, rigorous, or harsh. Well, and by God, that citation to that definition in that case is Webster's Third New International Dictionary. In other words, at that time when the court wrote that opinion, they didn't have a single other thing to go by except Webster's International Dictionary. I mean, I could also suggest a definition for oppression, and I'll bear with me for just a minute. I have it here. This is a definition for oppression that comes from Black's Law. And it simply says, what is oppression? It's the misdemeanor committed by a public officer who, under cover of his office, wrongfully elicits upon any person any bodily harm, imprisonment, or other injury. Okay, so did that occur? Well, no, I don't think that occurred. All right. What I'll tell you is that with respect to that incident and what you set out there in item number 2, I don't believe the mayor could have been oppressive because it wasn't his final determination as to whether you got to speak or not. It was ours, we did this. Okay? I'm gonna set out, and I'm gonna give you that incident could have been handled better. I think if Bill had taken a deep breath and counted to 5, we wouldn't be here. But be that as it may, here's another definition. Here's another definition. This comes from the Landstrom case that I'm sure any attorneys in the room are familiar with from 1997. And that was a dispute over how a business was being handled and the proceeds from the business were being shared and so forth. And with respect to oppression, it states that, and this is from paragraph 42 from the opinion, for those that are going to research it, oppression is based on the totality of factual circumstances and is not relegated to a bright line rule or implementation of a checklist. While a single act may not amount to oppression, under the totality of all relevant circumstances of the case, oppression may be found to exist. That means to me that a court could look at this circumstance and say, well, there's one incident under number 2, one evening, when the mayor could have handled the situation better. Is that grounds for oppression? Is that grounds for removal of office? If you follow that opinion, the court would come to the conclusion, no. If that having been said, I'll make a substitute motion to reject the petition based on there not being sufficient claims to support the grounds stated in the petition as required by SDCL 91330.
I'm not a rules of order kind of guy. I don't understand everything, what's allowed, what's not allowed. Is there a way to take like 5 or 10 minutes just to kind of take in everything that's been shared, so that way I can go through this petition top and bottom and go against the criteria that our city attorney has provided to see if it meets the definition? Because as of this evening, all of those guidelines are new to my ears. I want to make sure that I'm making the right decision.
First of all, we need a second on the motion or not. We have a motion on the table, a substitute motion on the table, I need a second. Second.
I move to call the vote.
Is there a second to call the vote? Second. All right, okay, so, motion has been made by Mark, second by Ryan to call the vote. So, Mark?
Yes. Wait, to call the vote
To
or?
call the vote.
Yeah.
Yeah. Yeah? Brett?
So if I want to take a quick recess, I should say no at this point?
Wait.
No.
Okay. Scott?
Yes.
Bill? Yes. Sorry, Brett, I'm being yes also. Okay. Now, the motion, we're voting on the substitute motion. Karen, can you please reread the substitute motion?
Bill made a substitute motion to reject the petition based on there not being sufficient claims to support the grounds in the petition as stated in South Dakota Codified Law 9-13-30.
Okay. So now we're voting on the substitute motion. Okay. Scott?
No.
Mark?
No.
Brett?
Abstain.
Sure is.
Ryan? Yes.
Yes.
I'm going to vote. I'm going to abstain also.
Motion dies.
Motion dies. Now we're going to Mark's motion. To set, what was Mark's motion again, Karen?
First Tuesday in January.
First Tuesday in January.
Which is which date?
That would be January 5th,
January 5th. Okay.
2016.
And that falls in the 20 days.
That falls in between 30 and 50.
Yeah,
So we have to
the
be
20 days between 30 and 50. I couldn't see because of all the cameras.
Yes.
Scott,
Yes.
Mark,
Yeah.
Brad,
Abstain.
Brian,
Yes.
Bill,
No.
and I'm also going to abstain. So that motion dies also. How can you abstain? What's that?
It's not a tie vote.
Well, I still get to.
There's not a tie vote. There's nothing.
There was 3
Right.
votes, yes.
There was 3 votes, that, like I said, there was 3 votes for yes,
Four
And one no.
has to have-
but it needs 4 to pass the measure, 2 abstained.
2 minutes.
So here's the next thing that's gonna happen. We got 10 days to set a date, or we, as a council, are in violation of law.
Not necessarily. As it stands right now, the petition wasn't rejected. The petition was not validated.
Was it presented? This says when the petition is presented, you have
We
10
haven't
days.
decided whether we have a petition pursuant to 9/13/30.
I think it's been established that the petition was presented.
A petition was presented, but we haven't established it's pursuant to 9/13/30.
Does the law say that it has to be, the petition has to be
Yeah.
taken? That's what it says.
It's saying that.
Where does it say that, or are you just reading that into?
I'm reading the two statutes together.
Council, please.
9/13/31 does say.
Within 10 days after presentation of the petition to the governing body, the governing body
What are you reading
shall
from?
order and fix a date.
What are you reading from? You're reading from the municipal league. Yeah, well, it does matter because it's not the statute. It's an excerpt from it.
I'd like to call order, okay? What are our options right now?
I'll make a motion that we set the election for December 29th.
Second.
I call a vote. I move to call the vote.
Second.
Okay, motion's been made and seconded to call the vote for an election to be held on December 29th. Scott,
Yes.
Brad,
Abstain. I don't have the opportunity to sit down and make a good educated decision based upon the information that's been provided. I'm simply asking for 10 minutes, 5 to 10 minutes to sit down and make that decision.
Mark.
You've been here all evening, why can't you make a decision?
Guys, hey, we're having a vote right here, please.
We're voting on
Voting
whether to call the vote.
We're just voting on whether to call the vote. Okay?
Who's voted already?
I voted yes.
Yes.
Brad is abstained.
Okay.
Mark?
Yeah.
Ryan?
Yes. It's true.
Call the vote.
Oh, yes.
And I'm gonna vote yes. So we're gonna call the vote. Okay. Mark?
Yeah.
Ryan?
No.
Scott?
Yes.
Bill?
No.
Brad?
Abstain.
I'm going to abstain also. I'm going to ask for a motion for a short recess.
So moved. Second.
Okay. All in favor?
No, you call it by name. You call that vote by name.
Okay. Scott?
Give it to me again, make sure I understand what you're, to take
Basically,
recess?
take a 10-minute, did I say 10 or 5?
Just a short.
Okay, let's make a specific time period.
Well, we've been here
This is
for
fine. Short
2
recess,
plus
yes.
hours, make it 10 minutes.
Friendly amendment allows you
10 minutes. 10 minutes. 10-minute amendment, okay.
Got it,
So,
yes.
10 minutes. Bill?
Moving for a 10-minute recess.
Yeah.
Yes.
Mark?
Abstain.
Abby, so we are going to be in recess for 10 minutes. Okay? This is a recess, so you do not have to leave the chamber. I'm going
I thought I asked him. Good to see you.